perhaps then we could formally start, and you could say who you are and what you do and why you're here.
My name is Elaine. I'm chairman of Balfour and Manson Solicitors in Edinburgh. I am a litigator, and I was and remain one of the original trustees of the Variant CJD Trust, which signed off in 2001, and I came on board when everything started in 2002. I think the trustee was signed off. I'm sure you're all very much aware of the background to the trust itself, but it started off with the first.
Shall we just introduce your colleagues so that we
sorry,
get
I
it
do
on?
apologise. This is Jonathan Zimmern of Field Fisher.
Yes.
Field Fisher are the secretariat for the trust and have been absolutely indispensable in the running of the trust smoothly and the compensation for victims. And I'm sure we'll come on to questions like that later, but specialism certainly is something that I think was key to the trust running as best as it could.
So, Jonathan, could you just say who you are so we've got it on the record?
Yes, certainly. My name is Jonathan Zimmern. I'm a partner at Field Fisher Solicitors. I primarily do clinical negligence work, but I've been involved as the lawyer for the trust since I was a paralegal back in 2002 or 2003, and I've been working with Elaine and her team pretty much solidly since that time.
Right, thank you very much indeed. And I just wonder if you could speak up a little bit.
Certainly, and please let me know if my accent causes any difficulties. I'm sure you'll let me know as well.
It's just we're a bit deaf.
Well, so am I, so I get that. Yeah, the trust came about by way of a cohesive meetings between representatives of 117 victims and the government and a team. So it was very much a joint project to have the trust set up, and I think that was and remains absolutely key to the success of getting victims' families to actually buy into and trust what we're doing for compensation. So it was a joint effort. The trust deed, when it first came out, was incredibly complicated. And while there are huge benefits to that in giving the trustees the ability to have some discretion in cases, but also to have the foundation to explain to victims why they could or could not do, or victims' families, more importantly, why they could or could not do things. It was a very complicated document, but it was what the families wanted and what was agreed with the DOH at the time. As the cases developed and as the trust developed, it has been varied 3 times, and it has been simplified right down to make it more cost effective and probably equally, if not more importantly, easier for the families to actually apply for and get compensation. One of the issues that we found right at the beginning, and I promise you, we spent a few days at Heathrow Airport Hotel doing our first tranche of claims, and the room, probably this size, was full of files because of the amount of information that we were having to gather. And families and the victims and their families were providing huge amounts of information, some of which was relevant to the trust deed and some of which was not, but it took a huge amount of effort and emotional stress to provide that information to the trust, and frequently we ended up having to go back to get clarification or request additional information. And of course there were all sorts of different heads of compensation in the trust deed that people could qualify for and apply for. So if you put all of that together, you get a combination of emotional stress as well as a lot of cost involved in actually processing the claims. So after a number of years, we went back to the Department of Health and we got permission to simplify the trust. Now, going back to the Department of Health was great, but it was time consuming as well, and that brought its own problems in terms of families waiting to hear if we'd managed to vary a trust, to either to try and give them the compensation or to simplify it. And so, whilst it was a good thing in many ways, it had disadvantages in time and cost involved in actually getting those variations. So I suppose where our starting point is is that if any other trusts should be set up in the future, they should be as simple as possible. And but balancing fairness and making sure that the right people get the right compensation, and that's not an easy task.
I think just to add to that, I think that actually the people who are seeking compensation don't necessarily always know what it is they want. So when I understand that when the scheme was first put forward, the suggestion was a simple lump sum, but actually those family members of the first 117 victims fought very hard that the scheme should be more complex, with more discretion and more ability to look at the individual circumstances of those who are affected. But of course, as the years ticked by, it was exactly that requirement to delve into the individual circumstances of each family that caused the most upset. And so I just think that there is a kind of unintended consequence to decisions made very early on that should be thought through very carefully.
That's very helpful, good advice. Thank you very much. Can I just ask you on your system, because I don't really understand it. You've got obviously claimants, and I do know with CJD it's quite difficult because you really only know when you have a post-mortem, which of course is too late. But you have these qualifiers, and I'm not quite sure. It seems the qualifiers are members of the family or the spouse or whatever. Could you tell us a bit why they qualify?
Well, again, I think it was part of the negotiation to include as many family members or as possible in the scheme, and that brought its issues in terms of identifying the qualifiers and then trying to allocate compensation to them under and in terms of the scheme. I'm pretty sure it came about because of the negotiations.
Did it have a precedent? Were you able to look elsewhere and say, oh yes, that's how they did it elsewhere?
No, I don't think so. I don't think so. Do you?
Well, very broadly, the whole scheme was based on common law principles and the Fatal Accident Act, and the reality was that people who have vCJD don't live for very long. So actually the people who were most affected by the death, the horrible death that it was, are the people left behind. So the obvious example was the children or the spouse who were financially dependent on the person who died. So very broadly, the qualifiers were designed to be a list of people who might have been impacted by the death. And one of the very difficult jobs that the trustees and we had was that the way the scheme is worded is that you have to identify every qualifier who might be eligible, even if only to disregard them. And a very common situation would be you would have say for instance a marriage would have broken down, and very acrimoniously, and the wife would tell you that the husband had nothing to do with the child who died of vCJD. But of course the husband would then appear out of the woodwork a year later, and it turned out had in fact been very heavily involved. So the scheme was trying to get the balance right between making sure everyone who might have been seriously impacted by the disease had a voice, but also not, well in fact I don't think it did the balance very well, but trying to make sure that we didn't spend too many hours looking for great Aunt Bess in Australia who'd never been around.
I'm just a bit confused. Can you just tell me what proportion of the cases came from children given growth hormone, and how much from bovine and cattle?
I don't think any.
If any, it would be one or two. It was almost
sorry, one or two.
Yeah, tiny proportion.
From the growth hormone,
Yeah.
because I'm a retired paediatrician. I can remember that being a huge issue,
Yes.
but that's not materialised.
It's not come to pass. As you know, the scheme was set up for the first 250 victims, and we're on number 186 at the moment, 17 years on, which in many ways is fantastic because it's not developed in the way that was feared, but it brings its own challenges
So
in terms of...
pretty well all your cases are from bovine spongiform cattle.
some blood infection from,
So can I ask you, going back to the families, how wide, in order to qualify for the compensation, does the family have to be a carer, or can it be even wider than that? They might not live with the victim, as it were, but but how wide do you go? Do you go to the in-laws who live somewhere else, or what is your criteria?
Well, in some ways, I wish I could show you some of the diagrams that we had to put together of family relatives. Literally, some of them would go, 2 or 3 A4 pages of the family members. So sometimes we had to go very wide indeed. So it did go beyond carers themselves, because of course in terms of the deed there was compensation for carers as well, over and above the general compensation itself. So in fact I think it just went to...
So it's set out in the definition of qualifier in the deed, but it is husband, wife, child, including stepchildren, siblings, parents, grandparents, cousins, and all of that by marriage as well. So it was a very large qualifying group for each victim.
So the cousins might not even have much contact with the victims.
Absolutely, but the problem was that we had to contact the cousins in order to ask that question. Because of course some families you had the cousin who'd brought up the boy or whatever.
Does having that breadth of potential qualifiers give rise to greater potential for disputes and even litigation? And is that what happened?
I don't know litigation. It certainly widened the scope for disputes and upset, because if you would find that they may have been the second cousin but they had nothing really to do with the victim, then they wouldn't be getting any part of the compensation. So you contacted them caused upset for no reason. So yes, it does. And Jonathan's quite right. There wasn't a trust that we referred to by way of, as an example or precedent, but in terms of common law, and Scottish law, of course, is different to English law on this in terms of the fatal accidents in Section 4. But so you can go very wide and deep in common law.
So you could have cousins, say a cousin who had been in the family home for 2 years or something and then emigrated to Canada or another country. Would you then have to be in contact with them?
Yes.
So what we as the Secretariat would identify those people, and then at the trustees' regular meetings, a decision would be taken based on the information that we had collated as to whether it was sensible to go and contact that person in Canada. But most of the time the decision was it was appropriate to contact the family members, simply because historically we had seen so many unusual and difficult family situations that it was not always appropriate to take what we were being told at face value.
Right, okay, well, other people may want to revisit this, but I'd just like to go on to the surveillance unit and how the surveillance unit interacts with the trust and the trustees.
And I'm sure Jonathan will add to this, I think the surveillance unit have been absolutely key as gatekeepers to the trust in identifying and signing off individuals who have succumbed to this awful disease, because of course, as we know, there are different types of different forms of this disease. So they have been fantastic in terms of their involvement. Right at the beginning, Richard would come down to London and meet with the trust and discuss and take us through and educate us, because as a lawyer I can do law, but I don't know the ins and outs until I'm taught it. So they were constantly and regularly updating us and coming down to speak to us, and absolutely key to the gatekeeping role.
So what is the surveillance unit? Is it composed of academics, economists, clinicians? What are they doing and who are they?
I know them as clinicians. Again, it's a unit at the Western General Hospital in Edinburgh that set this up, and I have, to be honest, I have not researched everybody who's in that unit, but I know that they are active clinicians and academics as well. I don't know, Jonathan, if you know any more.
I think that's right. Researchers, clinicians and academics, that they exist completely separately to the Trust, but what the very first thing that we do when we are contacted by a family is we write to Professor Knight, who sends a very short letter back which confirms or not whether the person had the disease on the balance of probabilities, and whether, according to their records, that person lived in the UK during the requisite period of time. And without fail, by the time we contact them, they're already aware of this family through the clinical pathways that the National Hospital database operates.
So they have that information.
Yeah.
What do they do with it?
Well, in terms of for the scheme, they just write us that letter, and that letter makes the people eligible to claim. But they have their own role in terms of research and treatment and that sort of thing.
Can I just ask
think
something? From sort of looking at your website, it seemed that there's a slight discrepancy between the numbers, in that it said that the Trust knows about 184 individuals, but the surveillance unit lists 178. So why is there this discrepancy, and what are those missing people, as it were?
It's because the Trust operates in terms on balance of probabilities,
Right.
and they operate on the much higher medical standard of, well, I can't remember what it is, but it's the equivalent of beyond reasonable doubt in the medical world. And as a result, there will be a few people within our 186 who probably didn't have variant CJD. But all we need is a clinical diagnosis from Edinburgh saying balance of probabilities.
So from the information that you're getting now, are there likely to be more variant CJD cases? Or have we seen the end of it?
That's the $1 million question, I think. Before I answer that, can I just go back to the surveillance unit? I think they also link into the activation of the care package that the families get, and I think they're key to that. So they're sitting in the middle, and everything spreads out from there.
So with the care package, do you have any sort of role in terms of the care packages at all? No.
The only involvement we have now in relation to care costs is where we have somebody who is out with the UK and therefore cannot access the care package, but are having to incur care costs. Now, that wasn't envisaged when the Trust was put together, so that was one of the variations that we asked to be put in, and so we have the ability to pay for care out with the UK if that's appropriate in certain circumstances. Whether there will be any more cases is, I think, the $1 million question. We know that we've had very few in the past 5 years.
But Richard Knight and the unit believes that there will be another spike, I think. And the reason for that, I understand, is that a lot of the research on CJD is based on the research that one of your fellow trustees, David Stevens, did in relation to the cannibals in Papua New Guinea, and it's the prion disease. And I don't understand the science, but they were able to demonstrate there was the hump, and then it went down, and then another one. So I think people believe there may well be another spike of new victims.
Because you had a spike in 2000, 2000. Number of deaths that occurred then, and then it went back down again. And now, according to your figures, it seems very low indeed, and indeed last 2 years there haven't been any. Is that about
Very low.
right?
It's very low, one or two in that period. And so, of course, one of the, I suspect nobody thought that we would not have been past the 250 mark by now.
Yes.
You know, that was, and to be honest, that was a concern in the early days when we had a lot of claims, was what was going to happen when we got to the 251st victim, and putting up a line in the sand on the number of victims who would be compensated, I think, could have been a problem then. And if we hit another spike, then something it's not for the trustees. You know, we are caught by the trustee. But it's
Was there not a commitment from the government to put a second tranche of funding if you reached 250?
I would have to remind myself of that. I'm sure they probably did say that, but there's certainly nothing has been extended in the trustee to actually do that. So there's nothing formal in place that confirms to us that if we have a 251st victim, we will be able to run on with the trust.
And I mean, in terms of going back to when the scheme was set up, one of the interesting things is sort of the government position for a long time had been that they weren't going to have a scheme, and then they suddenly sort of changed and was change over to saying yes, we are. That was also around the same time that there was the legal case on the growth hormone cases. How important was that legal victory in terms of getting this shift towards this scheme being set up, do you think?
I can't answer that with any certainty, but I know that there was a huge amount of pressure brought to bear by the families, by their lobbying and such like. So I don't know where the balance lies in terms of it, but you have to say that the families take a huge amount of credit for actually raising the profile and bringing it to the attention of the politicians to result in this. There are many other awful things that happen where trusts and schemes are not set up. So.
And I also think that there was a feeling at that time that there was actually going to be an epidemic. It was going to be enormous. It was going to sweep the country. And it's quite interesting how the numbers have been lower than those anticipated in your trust. Yeah. Simon?
Well, one of the things I was going to ask about is the compensation, the element of compensation that's about psychological impact of knowing that you might be at risk of contracting it, because I think I'm right in saying that's part of the compensation package. And that's kind of, well, both interesting, because it's quite a novel thought, and I'm interested in how you identify people who aren't showing symptoms but might be at risk, given that no one really knew what the total number of affected people might be. But secondly, how important was it to families that was included in the Trust's arrangements?
Again, because I wasn't involved in the negotiation, I can't say how much it was important at the beginning, but certainly dealing with the psychiatric claims, it came through time and time again how the families were very concerned that they may get the same thing because they eat the same food as their sibling or their husband or their partner or such like. And therefore recognition of that in the award, and although it wasn't specifically singled out, it would be part of the overall psychiatric award that was made. I think that was very important.
It is truly awful disease, and it happened very, very quickly, and you would watch your loved one kind of disintegrate before you, both mentally and physically, and without a doubt the family members were very badly affected. And in terms of the practicalities, once they were aware that this was part of the scheme, we would arrange for them to see psychiatrists who would prepare reports, and there were different types of award. There was a small kind of gateway award which you got if you had a particular diagnosis, and then there were 2 further awards if you could demonstrate, to use the words of the trustee, particular emotional or particular financial hardship. But again, it comes back to what we were saying at the beginning. I think the families fought for it, and it resulted in them getting more money as individuals, but it was by far and away the most distressing part of the application process for the families, and indeed also I think for the
So you
trust.
very particularly used the word impact earlier on. So if there was a psychological impact on a member of the family because of the stress within the family, that would be grounds for support.
Yes, for a claim, yeah.
And for a claim, and following the claim, grounds for support.
Not from the care package, if that's what you meant.
From the trust.
No, all the trust could do would be to award compensation, and they could then decide if they wish to obtain support.
But you would get compensation because of the psychological impact.
Yes.
So there were two tranches. First was £5,000. Now there were 410 applications for that £5,000, and 404 were actually paid out. When it got onto the particular emotional hardship, that was a very it's a very difficult thing for the family members to go through, and of course different experts would be used. There wasn't a panel of experts that were identified that people went to, so you got the trustees and the victims' families got a huge variety of types of report coming through, which raised its own issues in terms of that. But there were 217 particular emotional hardship claims, and 146 of those were paid. So we didn't, because it was particular, it had to be out of the norm, and therefore how do you work out what the norm is?
So just because you're a member of a family that's been impacted by this awful disease, you wouldn't necessarily get compensation. You'd have to show that you'd actually suffered because of it.
Yes.
And in 2010, that was when we petitioned the Department of Health to simplify the scheme. That was one of the things that we wanted to do most of all, which was remove that aspect of the claim process, because it was so distressing, so time.
So what is the present situation? If I have a relative who, I'd say my sister's been affected, and I've grown up in a family with this thing, and I come along now saying, you know, I'm suffering from stress disorder, which has been going on for years, would I get compensation for it?
You wouldn't get compensation for that head by itself now. What we have now is a one-off payment of 130,000, and we review it every year to bring it up with inflation. 135,000, I should say. But we've also got a payment of 40,000 as experience for the family, as well as a 5,000 care.
So I wouldn't directly have a claim.
You would have a claim on a portion of that pot.
But that would have to be sorted out within the family.
Yes, and that brings its own challenges.
Well, no, we would, the trustee, we would hear, we would gather information from the family, and then the trustees would make a decision as to how it should be distributed.
But sometimes it's agreed. Sometimes the families come to us and say, we have agreed compensation should be divided up X, Y and Z, and sometimes it is...
Thank you very much.
The initial, if we go back to pre-2010, the initial 5,000 psychiatric injury of qualifying family, that's more generous than you would normally get at common law.
Yes.
How did that come about? In terms of, usually as you say, the scheme was designed sort of looking at fatal accidents act. Why was that provision there in the first place? Was it family pressure?
So I think you're right, it is more generous than common law, but the concept of getting psychiatric injury as a result of losing a loved one is still part of common law. So I think my understanding was the heads of damage were broadly based on common law, but deliberately more generous.
Okay.
Because I think the horrible nature of the disease.
And also the right to actually sue still remained down to the families as well. So if you're going to put a scheme together, then you want it to be a bit more generous than the common law.
Yeah, can I ask about the care packages and how that works and how it's funded? So what I sort of understood, maybe I got this completely wrong, that Health and Social Services would be doing whatever they would do anyway in relation to the treatment of those affected. Now I appreciate there's a very short time span. Are you saying that if they needed extra, it would be funded by the department and through the trust that would call on the local healthcare provider to top up what they would normally do? How does it work?
The trust generally didn't have much involvement in the care package at all. The only rare occasions that we would get involved would be if we were getting families making application and highlighting that they, remember we actually had living victims as well, which wasn't anticipated by the trustee at all, and so you would sometimes have families come and say, well, the individual's still alive, but we're not getting the care package, and then we might write a letter but that's as much as we would do. What was given, what was allocated, and the timing of that was out with the Trust's powers.
So there was no top-up of care packages, there was
And in fact, the trustee specifically prohibits any payment in relation to care after March 2001, because it was envisaged that from that date, the care package operating in the background would be fully up and running for every single victim, which of course it wasn't. And we often got requests for top-ups which the trustee would not allow the trustees to pay.
So although there should have been provision, there wasn't.
Or not adequate provision according to the families. Yeah.
And in terms of, you said you were never expected to have living victims. Do you have living victims at the moment?
No,
we don't.
They were quite unusual, the living victims. I think two of them, possibly the only two, had got the experimental drug, which I can't remember the name of, and it worked insofar as it seemed to fix the disease at a given moment in time, but given how awful the disease was, I'm not sure that was necessarily a good thing.
But the trustees actually, 2 or 3 of us went to visit each of the living victims just to try and understand what life on the ground was like, and I can tell you it was awful, just awful.
The shrubbery, the vine shrubbery.
Yes, and also one of the other, and I know the trustee wonderfully actually gave us the power, but we ended up actually buying a property so that one of the victims could live in it until he passed. So again, the things that we didn't expect to have to do, but fortunately the trustee had been drafted in as wide a way to give the trustees discretion to do that, and we did it. And so I think I was on the name for an insurance policy for a house that I never saw until it was ultimately sold. So all of these different things, it's the unexpected that actually causes more difficulty than the expected. So allowing some flexibility in any scheme, I think, is essential.
And the scheme's it's clearly been quite a complex scheme to administer. Is that why the administrative costs are quite high? Simply the complexity of it compared to, say, the thalidomide or...
Very much so. And one of the concerns that we all have had for some years now is that as the number of claims reduce, there is still a base level of administrative costs that continue, and it's roughly £30,000 to £40,000 a year just to keep it ticking over. Then there are tax payments, annual audits. There's a very large 10-year tax payment every 10 years because it's a discretionary trust, and all of these things need to be paid even when people are not making any claims. And that, I think, is definitely something to consider when thinking about whether this is an appropriate mechanism.
As I understand it, the compensation scheme was set up by the Department of Health. So do you think there is merit at all in having independent charities or something of that nature that actually would be perhaps a bit more sensitive to costs and things like that?
I think what you need when you're dealing with compensation is expertise in that area, and as I said at the start, Charles Russell, who were the initial solicitors who dealt with everything, have the experience in trusts and administration and accountancy, which again is essential in terms of advising us of the tax payments, and they are huge in terms of the discretionary trust. I think the last one was about £4 million we had to pay in terms of that. But also then Charles Russell and then on to Field Fisher had the expertise in how to handle compensation and how to work with individuals, how to have the soft skills. I know that sometimes lawyers are not perceived in the best of lights, but one of the real skills of a very good personal injury lawyer are the soft skills, the ability to actually be more of a social worker than a lawyer to get the information you need. So I'm very strongly of the view that you need that expertise to actually draw the information. And this trust started off with lots of victims either coming themselves or going through solicitors, and we'd get a variety of quality of information coming through. in the latter years, Field Fisher have been basically funneling all the information and have been able to get that much more effectively and with much less distress and actually reduced costs than doing it any other way.
So is the trust still paying lawyers?
Yes.
Yes.
We still pay, and as I say, Jonathan says it costs about 40,000 a year to keep the trust turning over, because of course in theory no individual claim will actually close, because you never know when a qualifier might actually come forward. We have claims that opened in 2002 that are still potentially live claims, and that's one of the practical difficulties of not putting a closure date. You'll see in the trust deed that the date, the period is 80 years past the date of the first trust, long after I'll fled this mortal coil. So the trust has to effectively remain open for those potential claimants.
The costs have undoubtedly been higher than perhaps envisaged because the scheme is very complicated, and you could of course create a simpler scheme. But this goes back to the very first point we were discussing, that my understanding was that a very simple scheme was put forward and very, very firmly rejected by the people for whom the scheme was designed. And if you want a complex scheme that's tailored to each individual circumstance, it costs money. And even though there have only been 186 victims, and I'm afraid I don't have the exact numbers, there have been hundreds of qualifiers, 800-900 plus qualifiers, all of whom have a file, all of whom there's been a meeting about, all of whom we've had to collate individual information about in order to make a decision.
And many of them have had their own lawyers who have been able to put their costs to the trust for payment. So,
one of the things I'm interested in, you said that obviously as a discretionary trust, the trust pays tax. That sits in contrast to, say, the thalidomide trust, which the government has always put on a tax-neutral footing. Was there ever any discussion about that, about shifting the trust onto a tax-neutral footing?
I'm sorry, I can't answer that. I can try and find out if you'd like, but it's not something I was involved in.
I don't know whether it's the same point, but the trust is a discretionary trust that's entirely separate from the government. And over the years that has actually proved a good thing, because things like the Freedom of Information Act requests have been made a lot. People have attempted to judicially review the trust, and there's always been these allegations that the trust's kind of in the government's back pocket, and because it's so separate, they have been very easy to say that that's not right, and whether it's completely independent. And what I don't know is whether you have to have the discretionary trust and all the costs that come with it in order to have that distance.
No, that's been very helpful.
Questions. So we've got no more questions of you at the moment. We may send you some follow-up questions, possibly. Have you any questions for us?
I don't have any questions. If you would like the statistics of the claims made and the numbers, then we're very happy to send you down a little schedule of that, if that would be of any assistance.
That's not too difficult for you.
No, absolutely not.
We can send what we can, and then you can always ask if you want more detail.
Well, thank you so much.